have Clifford D'Souza now, who's called in from Mumbai. Clifford, thank you very much for calling Property Hotline. What's your question?
My name is Clifford from Andheri, Mumbai. I would like to know the difference between the nomination and will.
Difference between nomination and will?
Yeah, one. Number two, we have an elderly couple in our society, and the husband has expired and appointed his wife as a nominee. Okay, he is expired without making a will interstate. Now, if only on the basis of nomination, the wife being a nominee, can the flat be transferred in her name? And he, as being not made any will in her favor, what are the other requisites required to transfer the flat in her name?
Okay.
Apart from the sale agreement, the death certificate, and probably nomination is the only requisite for transfer of flat in her favor?
Right. That's a great question, Clifford, because nomination and being a nominee to a property and being an heir to the property according to the will are two very, very different things, right, Avikshit?
Yeah, so time and again we receive this question over and over. So see, the stand is very clear. As far as a nominee is concerned, it has been reiterated by a number of courts that a nominee is nothing but a trustee. So effectively what happens is, I'll give you a background. What normally the tendency of appointing a nominee is when a person expires and by the time you complete your entire legal procedure, there is a time gap here. So for that time gap, you appoint a nominee where that nominee is the person with whom the society will interact. But a nominee effectively is not the owner of the property or not an heir of the property. As you rightly said, there is a requirement of a will. And in the case there is no will, then it will be guided by the succession rules of the person depending on his religion by which he was guided. So in the present scenario, if there is no will, then as per the laws of interstate succession, you will have to make an application asking for a letters of administration in the Bombay High Court. This comes from section 52 of the Indian Succession Act, especially in places like Bombay. So I gather from the way you've asked the question, I presume you must be one of the members of the society and this query has come to you. So you must be in a fix, but you have to maintain your stand that till the time you get a direction from the court which appoints an administrator of the estate, you will not act and you will not transfer the name in the society records.
Right, so nominee and trustee nominee and the heir are two different people. Also, since we are talking about inheritance, just take us through the process. What happens? Say I have property. What should I do? One is obviously nominating somebody that person will take over in my death and will deal with the society is what you're saying. Now, how do I ensure when I make that will, can the nominee be a witness to that will as well?
Yeah. So a nominee can be anyone. It can be a third party who has nothing to do with the person whose estate is concerned. And a nominee, so the law with relating to witness is that a person who is witness to a will should not be a beneficiary under the will. Okay. So that is the only law that surrounds it. And nominee need not be a family member. You can just appoint anyone whom you can trust and who is, diligent enough to take care, pay all your taxes during the interim period so that, there is no liability that comes across.
But the nominee can be one of the family members as well.
If he is not getting any benefit under the will, yes.
Okay. So the nominee should not get any benefit.
Sorry, I stand corrected to that extent. I'm talking about the signature under a will, but yes, it can be a family member also. Sorry, even if he gets any benefit under the will. Sorry, I stand corrected.
So right. So that is a key difference, and that is something that you need to remember. If you own property, you need to make a will. Merely nominating somebody in your housing society does not solve the problems of inheritance. A nominee can be a family member, could be a friend, could be anybody you trust. The nominee need not be the heir to your property. The nominee and the heir are two different people. Also remember that a nominee is essentially a trustee, somebody who takes care of the maintenance of the property, paying the bills, etc., till the heir steps into the picture. So these are things that you need to make very clear if you own a property.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.